You may be wondering what's happening with all those question forms of yours, and please rest assured that whether your question involves a dart or a laurel, it will be answered in the wrap-up portion of today's program, which will take place between 4 and 4:30. I'd now like to introduce our panel dealing with summary conviction appeals and extraordinary remedies. This panel is chaired by the Honorable Mr. Justice Then. Mr. Justice Then practiced as counsel, later senior counsel, deputy director, and ultimately director of the Ministry of the Attorney General's Crown Law Office Criminal. In October 1989, he was appointed to the Supreme Court of Ontario High Court of Justice, and on merger in September of 1990 became a judge of the Ontario Court General Division. He has been a panelist in many educational programs concerning the criminal law, and I'm indebted to him for coming today. To Mr. Justice Then's left, to his right, from your perspective, is the Honorable Mr. Justice Paisley. Mr. Justice Paisley was appointed to the bench in 1989. He was then appointed to what was the District Court of Ontario and became a judge of the Ontario Court General Division with merger in September 1990. I dealt with Mr. Justice Paisley several times as counsel and always enjoyed dealing with him and felt that he epitomized the very best of the criminal defense bar. Prior to his appointment, he acted as chair of the Canadian Bar Association Ontario Criminal Justice Section and the Civil Liberties Section, and was a director of the Advocate Society. Now, on Mr. Justice Then's immediate right is Mr. Bruce Durno. Bruce practiced for many years with David Humphrey, as he then was. He was called to the bar in 1978 and has a practice restricted to the practice of criminal law. He is treasurer of the Legal Aid Committee and is the chair of the criminal subsection of the Joint Committee on Court Reform. To Mr. Justice Then's left, I should say to Mr. Justice Paisley's left, is Mark Sandler. Mark Sandler practices with the firm of Cooper, Sandler, West, and Skurka here in Toronto. He was called to the bar in 1980 and is a frequent panelist in programs of this type. Next to Mr. Sandler is Murray Siegel. Murray Siegel was called to the bar in 1977. He is currently the director of the Crown Law Office Criminal, and Murray's many publications include the recent and timely annotated Rules of Criminal Practice and such standards as breathalyzer law in Canada, the Manual of Motor Vehicle Law, and the Canadian Charter of Rights. Closest to me is Mr. Robert Hubbard, and Bob is currently General Counsel with the Criminal Prosecution Section of the Toronto office of the Department of Justice. He specializes in complex trials, usually involving white-collar crime and appeals. He was called to the bar in 1977. Thank you for your attention, and I'll turn it over now to Mr. Justice Then.
Right. Thank you very much, Brian. Well, let me introduce our panel today on summary conviction appeals and extraordinary remedies by telling you that we plan to spend most of the time available to us dealing with summary conviction appeals, if for no other reason than to reflect the fact that there are much more of those types of appeals than applications for extraordinary remedies. Also, I should say that our format will be really to deal with issues as much as we can rather than to try to deal in chronological order with each and every section that deals with our topic, although, of course, we will, of necessity, have to touch on some of the sections in the course of our discussion. And thirdly, because I do have the advantage of two very experienced defense counsel, 2 experienced Crown counsel, and a justice of the General Division, what I will try to do as much as possible in respect of each area and each issue to give you the perspective of the Crown, the defense, and the judiciary. Now, to begin, what I'd like to do by way of overview is to ask Mark Sandler, in general terms, what are the major changes in the rules governing summary conviction appeals, and as defense counsel, how will these changes affect your practice?
Thank you, my lord. Well, at the outset, let me say this, that if one had to, in a snapshot, capture the major changes that these rules accomplish in relation to summary conviction appeals, one would simply say that the rules as to summary conviction appeals have been made to mirror, to a large extent, the rules that presently exist in relation to appeals on indictable matters. And you'll see from the rules themselves that appeal books, by way of example, and factums have now been made mandatory in relation to appeals on summary conviction matters. Rules that relate to which transcripts should be ordered, to the procedures for applying for stays pending appeals, and we'll be talking about those in more detail down the road, and the procedures which are now in existence for applying for bail pending appeal in a most significant ways parallel those that you may be familiar with when an appeal is being taken in relation to an indictable offense. From the perspective of the defense bar, in my view, and I'll elaborate upon this in a moment, the most significant change to our practice will be that because of the considerable amount of steps and paperwork, frankly, that is now involved in perfecting a summary conviction appeal or in applying for stays or bail pending appeal, as I say, in my view, defense counsel will have to evaluate more extensively the merits of a summary conviction appeal before embarking upon the expense and the time of launching one. Now, I'm going to deal with some of the specific changes that now are found in the rules in relation to summary conviction appeals, and then what I contemplate we'll be doing is discussing some of these areas in more detail as the panel proceeds. First of all, Rule 40.03 contemplates that the time in which to appeal from conviction, sentence, or both is 30 days from the date of sentence. So that this is brought into line with the rules in relation to indictable matters, and again, whether it be an appeal against conviction or sentence or conviction and sentence, the defense has 30 days after sentence to file a notice of appeal. Secondly, the notice of appeal itself is set out in Form 2 of the rules that are found in the materials that you have. And for those of you who have done summary conviction appeals, you'll notice that the format is slightly different from that which we presently use in 2 most significant ways. Firstly, you'll note that you don't particularize the date of offense, the date and location of the trial, the length of trial, and so on, as you often see, or as you invariably see on the first page of the present notice of appeals. We have a streamlined notice of appeal now. And secondly, you'll see that the notice of appeal contemplates your listing the specific dates that the trial took place. And that will facilitate the ordering of the transcript and certain other procedural rules that exist. And again, time really doesn't permit me to take you to each of the rules, but be aware of the difference in the notice of appeal that now exists. Next, you'll see in Rule 40.04 that very specific rules have been set out for service of documents on a summary conviction appellate matter. And I bring to your attention the most important of those rules, and that is service by facsimile transmission, because I find it most helpful to serve most of my documents nowadays by way of fax, and there are very specific procedural requirements as to how a document is to be served by fax. Next, you will see under Rule 40.06 that there are rules as to what transcripts are to be ordered, how they are to be ordered, and again, for those of you who are familiar with indictable offenses, you will recognize these rules because, again, they track the indictable appeal rules. They set out what is ordinarily to be required, and by way of example, I know all of you know that when you order a summary conviction appeal transcript now, almost invariably you get the kitchen sink, you get the submissions, you get the argument, you get objections, and so on. Now the procedure will very much parallel that for indictable offenses, that those kinds of things will be omitted unless you obtain specific leave to order those additional portions. So that when you are involved in a summary conviction appeal, take notice of that, because you will now have an obligation to consider at a very early stage what portions of the summary conviction appellate transcript you will require for the purposes of your appeal. Now, a notice of appeal is filed in much the same way as previously obtained, and a supplementary notice of appeal can be filed without leave prior to the filing of the appellant's factum. And that's a small change, but I note it for you because I was in a habit of filing my factum when I did file a factum on summary conviction appeals, and then my supplementary notice sometimes followed or lagged behind. You should get that supplementary notice of appeal in either contemporaneously or prior to filing a factum. Next, appeal books are now required under Rule 40.08. And for the purposes of my overview, I don't intend to elaborate upon what is to be found in an appeal book because it is set out in great particularity under the rule itself, but I point up to you that this is a very significant change that again will put the onus upon counsel at an early stage to ensure that all of the documents and orders and bail orders and stay orders and exhibits and so on that are necessary for the appeal are reproduced and contained in an appeal book. And again, this will be an easy task for those of you who are well acquainted with the rules for indictable offenses. For those of you who are not, I suggest some careful scrutiny of the requirements for appeal books. Next, the rule has been changed in relation to when a summary conviction appeal is perfected. You'll note that, and I'm generalizing here, but you'll note under 40.09 that generally speaking, an appeal is perfected when the clerk of the court has received from the trial court the documentation that relates to your appeal, when the transcripts have been ordered and filed, and when your appeal books have been ordered and filed. And it's only upon the filing of your appeal books that an appeal is ready, it's perfected, and it's ready for listing. And again, this is a significant difference which will come up again, I'm sure, in the course of the panel discussion, but it's the filing of the appeal book that will then trigger the perfection and setting a date for the hearing of the appeal. Next, and probably the most significant change in my view, is that factums are now required. Now, for those of you who practice in jurisdictions other than Toronto, for example, in Brampton, factums are already required, as I understand it. But for those of us who practice in Toronto, this is a new phenomenon indeed, and again, the quality of factums very much will influence your success or failure before the summary conviction appellate court, so that obviously the corresponding quality of your factum will be a very significant factor indeed. Next, I point up to you that when your appeal is against sentence only, a format, a very specific format has been set out in Form 19 for the factum to be filed. And again, this mirrors what is now occurring in our Court of Appeal for indictable offenses. And what it does, in effect, is it provides you in a very detailed way with what is expected to be in a factum for an appeal against sentence. And you'll see the details set out: time in pretrial custody, prior record of the appellant, and they set it out in numerical order, which you are to follow with some concise facts as well. It also sets out a procedure whereby your fresh evidence can be enclosed directly in the factum with the consent of the opposing party without a separate application to introduce fresh evidence on appeal. The next point that I would direct you to is the fact that on appeals against sentence, there is now a time restriction imposed. And again, those of you who practice in the Court of Appeal will know that this mirrors what is transpiring there. You have 15 minutes to argue your appeal against sentence. The Crown has 10 minutes, and you have 5 minutes to reply. All of these rules as to time can be abridged or extended. It'd be difficult to abridge those rules. But those time limits can be extended, but again, it places an onus upon counsel for both sides to ensure that your factum is clear, concise, and to the point, and it also imposes an onus upon you to get to the point when you're arguing an appeal against sentence. Finally, two very significant areas that will be dealt with in more detail in a moment, so I won't elaborate upon them now, but there are very specific procedures now set out for applying for a stay pending appeal, and that would be, for example, a stay of a driving prohibition order, and that would also be a stay of a fine, stay of probation, stay of a restitution order, stay of a community service as part of a probation order, and specific material is now required on such an application, and similarly, specific procedures are now set out for the kinds of material that have to be filed on a bail pending appeal. We're going to elaborate upon those in a moment, but in my view, from the perspective of defense counsel, 3 points. The first is, as I indicated at the outset of my comments, you will have to evaluate the merits of a summary conviction appeal in a more timely way than we perhaps presently do, because it is no longer sufficient to throw your notice of appeal in and then wait for a year or half a year down the road to just see how things develop. Again, the court will be asking of you a great many things. For example, if you apply for a stay on a prohibition order, you now have to file some considerable material indeed to justify a stay pending the hearing of the appeal. So that, again, you have to evaluate the merits relatively early in the process. Second of all, you have to consider within your own office and with your clients the additional expense that will be involved. And I think all of us, without being crass, those of us who practice on the defense side of the bar will have to evaluate the fees that we charge for summary conviction appeals, because the work involved is considerable, and that may impact upon some of you in relation to the fees that you'll be charging for these kinds of appeals. And finally, it's my respectful view that if you are going to do a considerable number of summary conviction appeals, or for that matter, a few summary conviction appeals, that you establish within your office immediately a checklist setting out the kinds of things that have to be done to perfect a summary conviction appeal, and when those things have been done or need be done, because there are time limits imposed in relation to all of the things I've discussed, and it is important from your perspective to ensure that a summary conviction appeal is being perfected in a timely and appropriate manner. Those would be my initial comments by way of overview.
Thank you very much, Mark. Marie Siegel, again, in general terms, What is the Crown is your reaction to some of the issues identified by Mark, and how will these new rules affect the practice of crowns throughout the province?
Thank you, my lord. I agree with Mark's summary of the important changes, and I couldn't add in view of his the excellent job he's done. I'm going to focus my comments on the projected impact of these rules for Crown attorneys with respect to such things as legal culture and administrative pressures in the short run. What this is going to mean for Crown attorneys' offices in many parts of the province, Toronto being one noteworthy example, are added pressures, added requirements for staff, and I'll expand on that in a moment. But taking up Mark's point, what may counterbalance that is his advice that one now has to seriously consider whether one is going to embark on one of these appeals in view of the work. You have to be serious about it and work at it. In terms of the Crown attorneys, there's going to be a requirement for additional dedicated staff to respond to, most notably, summary conviction appeal factums, that new requirement, which is a province-wide requirement. As has been noted, such has been the case in Peel for some time, but in Toronto, where there are 600 or 700 summary conviction appeals launched in a year, possibly no more than 10% involve factums from appellants at the previous time. And while for example, in Toronto, the work of the Crown Counsel who are assigned to this task is to an excellent caliber. More people will be required to deal with perhaps several hundred factums that now may have to be produced. As well, one will have to think in terms of exploring new skills. I think we're all seeing this from what we've heard in all the panels today. There are many new requirements that will require being adjusted to. In terms of Crown attorneys, there will be I suppose a new and added premium on written skills to produce factums, the drafting of applications, the production of affidavits. This is something that's not restricted to summary conviction appeals, but is throughout the rules that will come into force on May 1st. Crown attorneys' offices will now have to be in a position to assign people at an early stage to review compliance of the rules. Are things being served on time? Are they in the proper form? One will have to gain a familiarity with the tactical use of the rules, both as a sword and as a shield. Of course, the experience that some of the Crown staff have in the Court of Appeal may serve to be invaluable. There's another practical problem, and that is that most Crown attorneys' offices don't have the support staff to deal with this. In that Crowns in many places have never produced factums, many of the support staff in Crown attorneys' offices are involved in clerical work as opposed to legal secretarial work, the preparation of affidavits and factums and so forth. With respect to factums, some novel solutions on the Crown's part may have to be considered, and we are looking at them. Should we be exploring, for example, standardized responses in where similar issues are raised in many appeals? We'll need perhaps to look at lines of communication between Crown attorneys' offices in terms of taking a common position in factums, there may well have to be linkages between the Crown Law Office Criminal, which in terms of how they deal with issues in the Court of Appeal, or they intend to, and as well the Crown Attorney's offices. The whole notion in many parts of the province going into an appeal hearing, applying one's best efforts without an appeal book, with an inadequate, sometimes an inadequate notice, without a factum, is going to see a lot of additional work on the part of the bar at large, and specifically the Crowns.
Thank you very much, Murray. Well, Mr. Justice Paisley, let me ask you, how will the changes in your view identified by counsel in a general way affect the general division? And from your point of view as a judge, what are the benefits of these new rules?
Well, I think that the rules are going to have a positive effect on the court, as I think that the new rules will have a positive effect on counsel. There is nothing in these rules, in my view, which good advocacy did not already require to have available in the procedures that are still being dealt with. The fact is that a good advocate would always have filed a factum, in my view, when arguing an appeal, and a good advocate would always have assembled the necessary papers in a fashion that would permit the court and the advocate to have ready reference to the matters that were going to be addressed, whether it be on an application for bail or for a stay or to argue an appeal. But looking at these in particular, firstly, I think that one change that will become apparent is that there will be a broader number of court centers where the appellant may launch and argue his appeal within a given region. So that if counsel is practicing in a region, for example, in the northern part of Ontario, and his client has been convicted in a southerly portion of that region, he may argue the appeal at any court center within the region. That will tend, I think, to spread the appeal work around within the regions. The particular impact that these rules will have on the judiciary is that judges are required at many additional steps in the process to involve themselves or to be involved. For example, Rule 40.06 requires that certain portions of a transcript be omitted unless otherwise ordered by a judge. It's not a matter of simply sending to the court reporter a letter saying, please include the argument of counsel on this particular evidentiary motion that occurred in the impaired driving trial. The court reporter will not be able to prepare that without a judge's order. Now, that sounds rather intimidating. If at first blush it appears that you're going to be spending a day of your time in a courtroom, having served a notice of motion to ask for a judge to order the court reporter or permit the court reporter to include 3 or 4 pages or even less of transcript. But I don't interpret the rules that way. I think that the rules at first blush look much more intimidating than they are or will be as practiced. The rules are to be interpreted in a way that encourages efficiency. And I think that counsel will soon ensure that when they have relatively straightforward applications that have to be made, they will simply ask their colleagues, their opponents, to consent. In civil matters, a great proportion of motions dealing with family law and civil litigation are dealt with by a judge in his office with no attendance whatever. We call them basket motions. And counsel simply file a notice of motion. It may be so straightforward that it's done ex parte without any notice to the other side. And in many cases, civil litigation is settled on consent. Consent is filed, judgment is issued. Most of the areas in which a judge has to be involved, in my view, will be dealt with on consent or ex parte. And I would think, for example, that an application to include 3 or 4 pages of transcript although a judge's order is required, would probably be interpreted by many judges in due course, and perhaps I'm going out on a limb, as permitting an application to be made ex parte simply by filing the motion and leaving it to be determined sometime during the week of, and leave the date blank. The counsel are, by Rule 4006 sub 10, required to make every effort to agree on a statement of facts. I think the counsel have to take that obligation seriously as a professional matter. I'm sure that the concern here is not to save the appellants $25 or $30 in terms of avoiding a few extra pages of transcript. Our real problem, as I see it, is in the judiciary, is ensuring that trials and appeals are dealt with within a reasonable period of time. Post-Askoff, I think judges have felt that they have assumed or have had imposed on them a burden of ensuring that the court system works as efficiently as possible. Perhaps that burden always existed, but now we feel it with extra force. And the chief cause of delay in getting summary conviction appeals on is that the transcripts can't be prepared as quickly as we would all like them to be, because there's a limited number of court reporters. They spend a lot of time of their day in the courtroom, and they work at night banging out these transcripts, or have their secretaries, if they have secretaries, to assist them doing so. And it takes sometimes several months, as you know, to get a transcript in a relatively straightforward matter. And if your appeal is on a simple question of law, and you speak to trial counsel immediately after the trial, knowing that you're going to get instructions to appeal, and simply say to trial counsel, well, his memory or her memory is fresh. Look, can we simply agree that this is an issue that can be reduced to a page by way of an agreed statement of facts? And trial counsel, if he's asked that question, well, he or she still remembers what the facts were, undoubtedly would be able to say so. And I interpret Rule 400610 as imposing a professional obligation on counsel, because it is worded as follows: make every effort, counsel will make every effort to agree on a statement of facts. So I think that out of a matter of self-respect, responsible counsel will honor the spirit as well as the letter of that rule, and thereby not only do well for their clients by reducing the delay that would otherwise be required in waiting for unnecessary transcript, but ensure that the court system is enabled to perform its responsibilities reasonably. I'd also point out that costs may be ordered under Sub-Rule 13 if unnecessary transcript has been prepared. This impacts on the judiciary. I don't think any judge particularly cares to be called upon to criticize counsel personally for the failure to perform their duty professionally. But that, in essence, is what the rule will require a judge to do. And I say, speaking for myself, and I'm sure for all of my colleagues on the bench, that is one of the most unpleasant responsibilities that we will ever be asked to perform, namely to criticize counsel. We all were formerly counsel. We all have sympathies for the difficulties of practice. But I point out that this is one of the rules that will involve our paying attention to whether or not counsel have, in fact, performed their duties appropriately in this regard. Also, I point out that from my point of view, these rules will make the job of being a judge and sitting in judgment on appeals far more pleasant, because I think that it is a much happier job to listen to a well-crafted appeal than to sit patiently while papers are being turned and pages are being fumbled over and the grounds of appeal are being defined in the mind of counsel as the appeal develops. Rule 4007 sub 2 provides that no grounds other than those stated in the notice of appeal can be argued. You may file a supplementary notice of appeal, but the message here is draft your grounds with care. There's nothing particularly imposing about that task. There is a craftsmanship involved in drafting the grounds of appeal. And if you go through 2 or 3 or 4 drafts of a 2 or 3 or 4 line ground of appeal until you arrive at something which meets your satisfaction, I think that you will soon appreciate that there is a lot of pleasure in crafting your appeals. I don't necessarily agree that the cost of arguing these appeals is going to skyrocket. I think rather that counsel will develop proficiency after they have done 1 or 2 appeals. The first one, the second one may be an imposing challenge, but before very long, this will be second nature. Real estate practitioners have clerks and they have secretaries who are skilled in performing the routine tasks of closing a sale or purchase of a house. And criminal counsel will soon have available the clerks and secretaries who will handle almost all of these routine tasks without their personal involvement except as in a supervisory fashion. And I don't think that there is anything terribly expensive about faxing documents or sending a courier to send documents here or there. Most of these things are just routine assembly of pieces of paper such as the information, the exhibits, and putting covers around them and binding them. But I say that it will make the task of a judge far more pleasant to hear a skillfully prepared and crafted appeal. And I think that will also, by the same token, make the task of appellate counsel that much more interesting, because you'll, by following these rules, have to acquire the habits of thinking about what the appeal is going to involve well in advance. The next issue where I think that the court is going to be involved is that the clerk of the court may refuse to accept appeal books if they're not prepared according to the rules, and they may not be filed except with leave of a judge. Now, here's another area where the judge is going to have to be involved. Does that mean a special motion day for counsel to appear to explain why they weren't able to reproduce the photographs that were filed as an exhibit, or why the pages, although they're not numbered consecutively, the appeal book should nevertheless be filed? Well, most of these things will simply be settled by taking back the appeal book and putting it into the shape that the rule requires. But if there is any problem, as I've previously indicated, I'm sure that basket motions will be the method by which this type of difficulty will be handled ex parte. Finally, then, there is the area of obtaining dates for appeal that have to be fixed by a judge. I don't foresee counsel appearing on a special day in summary conviction appeal court in order to set a date for the appeal. I think in most regions, the available dates upon which appeals will be argued will be fixed, so the counsel will know the dates that summary conviction appeals are going to be argued. Perhaps I'm speaking out of turn here. I don't know. It's not spelled out in the rules, but I don't think as judges we particularly care to receive a list of lawyers waiting for audience solely for the purpose of saying, November the 10th? Yes. It seems to me that what counsel will do is they'll find out what dates appeals are being heard. They'll phone an administrator in the courthouse and say, can my appeal be heard on X date? The administrator will say yes, and the appeal will proceed in that fashion. Finally, if factums are not filed by the date in the notice of appeal fixed in the notice of hearing, then counsel must appear before a judge. So here's another area where the rules impact on the judiciary. Wasted court time is something that I've previously mentioned worries us all. We set aside so many hours for the hearing of appeals. There's only about 5 hours in a day. We're not going to triple and quadruple book the appeal dates. We assume and accept that a reasonably argued appeal will take a certain period of time. We'll ask counsel and expect counsel to give us some advance indication. And if the factums haven't been filed by the date fixed in the notice of hearing, we are not going to be able to schedule additional appeals to fill in the time that would appear to be wasted by virtue of the fact that the appellant hasn't filed his factum and the respondent won't be able to file his factum either, or her factum as the case may be, in time for the appeal to be argued. There's going to have to be an adjournment in most such cases with the necessary waste of time. The point is, I think that counsel have to diarize their procedures. And if they do so, these rules are going to be very simple to follow and will cause you no unnecessary pain or chaos.
Well, thank you, Mr. Justice Paisley. I'd like to turn to the issue of bail now. And as Mark Sandler has pointed out, for the first time, summary conviction appeals are going to be governed by their own rules pertaining to bail. What I'd like to do is to ask Bruce Durno to outline the new regime for obtaining bail and to ask him how he would use the rules to expedite the release of his client pending a summary conviction appeal.
Thank you, my lord. The rule that deals with release pending appeal is Rule 42. There's probably 3 points that can be made as an overview with respect to these new rules for release pending appeal. First of all, as has been mentioned earlier, it's very similar to the rules of bail pending appeal and indictable offenses to the Court of Appeal. Secondly, if you can get the Crown to consent, you don't even have to go to court. That's the good news. If you can't get the Crown to consent, then welcome to the paper chase, because it's considerably more work and time will be required than it is at the present time. You're going to need your notice of appeal plus your reporter certificates from every reporter that was involved. I'll get to it in a minute, but you will also have to file, in the absence of a Crown consent, the original, or not the original, but a copy of the information which will include the reporters' names to facilitate your getting the certificates from those reporters. You'll require a notice of motion, basically in the same format as now: the date, the place, the release sought, what documents are going to be relied upon, if any time requirements must be abridged. The notice of motion must be in conformity with Rule 6.03. It's significant to note that you must give 2 clear days' notice to the Crown, pursuant to Rule 42.04(2). However, you can get the Crown to consent to abridging the time merely by endorsing the consent of the respondent, who, for me doing defense work, would be the Crown Attorney or the Department of Justice, to having the matter heard the next day or perhaps even the same day. And that's just endorsed on the notice, and then you take it to the court. What you're going to require, and of course it's the times that can be, there's 2 consents really for the bails. One is the time can be abridged on consent, and the other consent is to the order itself. The materials you're going to require, I've indicated a copy of the information. This is under 42.051. Your notice of appeal, of course. I'm not sure why there's a reference to a supplementary notice of appeal, but you wouldn't be at that stage, I wouldn't think, at the bail pending appeal. You need an affidavit of the applicant. I think the rules are clear. It must be the applicant's affidavit and any other material required. The applicant's affidavit, set out in Subrule 2, must set out a number of things in the affidavit. The particulars of the conviction, the grounds of appeal if they're not in the notice of appeal, but presumably they'd all be there, where he's lived for the last 3 years, employment record, what hardship, and what terms are proposed. While the rules don't require it, it's probably a good practice to include in there as well the release pending trial, so that the justice reviewing the material will know what the terms were, and hopefully that the accused has been reporting faithfully for whatever number of months and abiding by the terms, the pretrial release. An added point for the Crowns is that if the Crown is going to oppose bail on any grounds of the public interest not included in the applicant's material, then the Crown has to file an affidavit. And you should be made aware of the fact that, of course, you can be the respondent can ask to cross-examine the accused on the application, on his affidavit or her affidavit, and presumably, I guess if you wanted to cross-examine your favorite Crown Attorney, you could bring the application on the grounds set out in that affidavit. There is, again, a section requiring or urging agreed statements of fact. If you're going to go through a full hearing on the bail, you must also file an application record on behalf of the applicant, which will include a table of contents, the notice of appeal, a list of transcripts, and all documents required. Again, the good news is there's no factum required. The respondent will also be required, if they want to rely on other documentation not included, to file the respondent's record. This is all for a summary conviction appeal, for bail pending summary conviction appeal. A judge may dispense with compliance with the rules where it appears necessary in the interests of justice. And hopefully that's going to be interpreted to mean short sentences. Surely to go through the procedures set out here for someone who gets a 7-day sentence, 5-day sentence, I think from the defense counsel's point of view, you're going to have to anticipate if it's in the realm of possibility that you're going to have a summary conviction appeal and bail pending appeal, to have the documentation prepared. Perhaps even asking in a polite way and creative way that the sentencing be held on some other date than the date the judge is planning on doing it, or if the judge wants to do it right away. I think I agree with Mark's comments that the entire result of these rules is going to be fewer summary conviction appeals. And would, with respect, disagree with Justice Paisley that the cost factor, you can't add all of these things to a summary conviction appeal and say, well, I'll do it for the same work, the same amount as I was doing it for the last 5 years, 10 years, or whatever number of years. And the legal aid issue, we could...
We'll get to that.
The 4206 sub 3 is the consent of the prosecutor in writing, and may result in a lot of lunches for Crown attorneys after the morning sentencing. Seems to me that's not necessarily the lunches, but hopefully, and I think in my experience, that Crown attorneys will take a realistic approach to these rules, and particularly on short sentences. Give you the consent, you draft up the order, get the Crown to sign it. The way I read the rules, you'd still have to file your notice of appeal and reporter's certificate. Then the order goes to a justice, and you don't even have to attend court with the Crown. The order's signed, and you can go and get the client out. I think that's summarizes the bail pending.
Well, thank you, Bruce. Well, I'd like to ask Bob Hubbard, first of all, on this issue of bail, how much consenting are you going to do? And is there anything other from a practical or legal point of view in these new rules to cause you to change your approach to bail pending summary conviction from, say, bail pending indictable appeals?
Well, I think that the speakers to date have clearly, at least on this issue, have clearly underlined that the main impact of these provisions are going to be felt by defense counsel. Obviously, they're the ones who are producing all these records and papers and so on and so forth. As far as the Crowns are concerned, subject to perhaps having to file the occasional affidavit in response or supplementing the record with the Crown's record, I think the Crown's job is going to be made a lot easier, as is the judges. Obviously, if defense counsel are actually going to comply with these rules and give complete particulars of the accused or the applicant's background, our job is going to be simplified by looking at one or two documents. And to some extent, it may be that we are more likely to consent now because we have all the documents up front. We can make an informed decision without saying, well, you know, let's see your material on the day off. Produce it to me. Obviously, with respect to short sentences, again, this is a heavy onus, perhaps, compared to past practice of defense counsel, but I think in the main, you're going to see more consensual matters.
Thank you, Bob. Any comments, Justice Paisley, on the bail issue?
Yes, I have two. Firstly, I'd refer to the interpretation rule 1.04. The general principle of these rules' interpretation is that they are intended to provide for the just determination of every criminal proceeding and shall be liberally construed to secure simplicity in procedure, fairness in administration, and the elimination of unjustifiable expense and delay. And secondly, Rule 2.01. A failure to comply with these rules is an irregularity and does not render a proceeding or a step, document, or order in a proceeding a nullity, and the court may grant all necessary amendments or other relief on such terms as are just. And Rule 2.02, the court may, only where and as necessary in the interests of justice, dispense with compliance with any rule at any time. The rules will not defeat the justice of the case. The rules with respect to bail pending appeal expressly provide that the time periods can be shortened. Obviously, counsel have to be in a position to know the case they are expected to meet. But I think that if we're dealing with a 3 or 4 or 5 day sentence as opposed to a 6-month sentence in a summary conviction appeal, one would presume that you're not dealing with an axe murder case. One would presume that there wouldn't be a great deal that Crown Counsel would have to know about the matter involved in a 5 or 6 or 7 day sentence in order to appreciate whether or not there should be a consent to the granting of bail. The only question, in my view, that would really be relevant is whether or not the appeal is frivolous or has merit. And that question will readily be resolved by looking at the grounds specified in the notice of appeal. And counsel, who is not always the counsel who argued the trial, counsel for the applicant, will be expected to have some idea of the facts that relate to the grounds of appeal and the reasoning of the judge, who in our province, as you know, has had at least 10 years experience at the bar before appointment, the reasoning of the judge who imposed the conviction or the sentence, which is under appeal. It shouldn't be presumed that merely because an appeal has been filed that bail is automatically going to be granted. And I think that if counsel are concerned that the rules are going to defeat the justice of the case, they're mistaken. Judges will deal justly with these matters, and I'm simply not persuaded that merely because there is some paper that has to be assembled, that necessarily means there's going to be delay. You know, as trial counsel, if your client is faced with a second impaired driving charge, he's previously been convicted, that he's looking at a minimum sentence of 14 days, or if it's a third, 3 months, as the case may be. And you know from your experience with respect to matters whether or not a client is likely to get a jail sentence. And in such a case, as trial counsel, undoubtedly you will begin to prepare the necessary documents and assemble them and have them readily at hand so that you will be in a position to apply on very short notice for relief in the event that your worst fears are realized.
Thank you, Justice Paisley. Let's turn now to the area of stays pursuant to the new Rule 41. Mark Sandler, could you take us through the procedure pertaining to stays? And secondly, could you comment on some of the practical impacts that this procedure might have on your practice?
All right. Well, I should say at the outset that Rule 41 is labeled stays pending appeal. It could have easily been labeled one method to avoid impaired drivers from frivolously seeking to retain their licenses. The rule applies in two situations. First of all, if you are applying to stay a judge's order prohibiting your client from driving, and secondly, it applies to a series of circumstances where a judge has made an order such as a fine, forfeiture of property, restitution, victim fine surcharges, probation, community service, and so on, which you are seeking to stay pending the hearing of the appeal. It's a particularly significant rule for a couple of reasons. First of all, there are certain misnomers about stays that exist in the profession. In the driving context, there are a number of counsel that assume that simply because a notice of appeal has been filed and a certified copy of the notice of appeal is provided to the ministry, that the client is thereby entitled to drive, confusing the Highway Traffic Act suspension that follows upon conviction with a judge's order of prohibition under the criminal code. And there are many people driving around as we speak who think that they have a valid driver's license because their counsel has not taken the appropriate steps to ensure that they are truly entitled to drive. Secondly, the rule is significant because, again, certain counsel are under the misconception that everything that is done by way of sentence is automatically stayed, whether it be a fine or whether it be probation, pending the hearing of an appeal. And many counsel have now experienced the phenomenon of having probation officers call them up and say, "Why has your client not come to me and reported as required?" And counsel says, "Well, he obtained bail." And probation officer says, "Well, that's not good enough because he's on probation when he's not in jail and there's been no stay on the probation aspect of the sentence." It raises some very interesting issues that won't be fully canvassed at this panel, but you have to remember that stays are not automatic in relation to all the things that the trial judge has done, and you have to give careful consideration to those issues. Now, an application for these kinds of stays are brought before the same court, a judge of the same court, that ultimately hears the summary conviction appeal. And service and filing must take place 2 clear days before the hearing of the application. And again, I would echo comments that Justice Paisley made, and that is that all of these rules contemplate that the time limits can be abridged and the materials need not be filed in appropriate circumstances, and diligent counsel can ensure that their client's driver's license is restored in a very timely fashion by working sometimes in advance of the conviction and sometimes immediately after the conviction, having anticipated what did transpire in the trial court. But in any event, the material that need be filed on an application for stay has been particularized in the rules. And my suggestion is that you must acquaint yourself with this particularization at a very early stage, because I expect that another misnomer that some defense counsel have, defense counsel are going to be disabused of a notion very early in the process, and that is, with the number of impaired driving cases that permeate the courts now, I expect that you are going to see, and are beginning to see now, a tendency on the part of the court to examine more carefully the merits of the appeal on an application to consider whether or not the driver should get his license back pending the appeal. And I expect the court will more seriously consider the hardship or the inconvenience occasioned to the accused by reason of the loss of his license pending the determination of the appeal. And that may be a function of the fact that there are a number of appeals without merit on driving offenses that have been filed in our courts. I don't know, but I expect you're going to see that tendency in the courts, and are beginning to see it now, and you will have to respond by a very careful application to persuade the court that the appeal has some merit, that secondly, it is not contrary to the public interest, that the driver's license be restored, and other factors that are set out, and I don't intend to go into them in great detail because an excellent article was written on this whole aspect by Rick Libman, and I can just tell you where it is. It's at 21 Motor Vehicle Reports, second series at page 287, and Rick sets out what, in his view, are the criteria for considering an application for stay of prohibition orders, and in my view, it very fairly deals with the issues to be resolved by the court. Anyway, I digressed. You will have to file an application record, absent consent to the other side or a judge's order, and the application record will contain material that is set out in the rules at Rule 41.04. And probably the most significant thing, two things that I would point up to you as a trap, and that is I can't tell you how many times I have been in court when the judge presiding has pointed out to counsel that just because there is an appeal filed does not mean that the court has before it your notice of appeal or the information before the trial court. In other words, you have to duplicate the materials in your application record. It's a discrete application over and above your appeal itself. Don't assume they have the materials that you've already filed on the appeal. And secondly, an affidavit in great detail is required now from the applicant on these prohibition orders, and you'll see the applicant is put to a somewhat heavy onus to demonstrate what his driving record is, particulars of the offense, his criminal record, whether he's addicted to drugs or alcohol, what steps he's taken to deal with that, what hardship might be occasioned by reason of if the stay is not entered, and so on. The final point that I would make, because time is brief, is that, first of all, no factum is required. But more significantly, I'll remind you of something that's not in the rules, and that is that there's nothing in the rules that speaks to the issue of the merits of the appeal itself. Again, don't be caught short by failing to address the merits of the appeal when you come to argue your application. And that may mean that you will be filing material over and above that required by the rules. For example, an affidavit from trial counsel as to the merits of the appeal, or if you can get it, a very short excerpt or the reasons for judgment in the lower court, or in the very least, you should be prepared to spin off your notice of appeal and explain to the appellate judge the merits of the appeal with perhaps some authority to indicate why it's an interesting or novel or substantive point.
Thank you, Mark. I'll ask Murray Siegel to comment on the very interesting notion I think that Mark has put forward, and that is, if I hear him correctly, that really the real appeal from a practical point of view in terms of summary conviction may be the application for stay. And Murray, what issues do you see arising from stays from the Crown's point of view?
Well, as previously canvassed by some of the speakers, the application record that is set out that need be filed is an excellent tool for the Crown. It's wonderful that everything is put in our lap. What the applicant must show is really a codification of some of the leading judgments as discussed in that article. The onus is on the accused to demonstrate on a balance of probabilities that the stay should be granted. A couple of comments about what Mark said. He spoke in terms of some merit, demonstrating some merit to the appeal, and I agree with that. It may be rather styled as disclosing at the early stage that the appeal is not frivolous, as well as indicating or demonstrating that a stay would not be contrary to the public interest. One of the issues for the Crown to determine is whether or not they're going to consent on the basis of this material. And we're assisted by the completeness of the material. We will be insisting in this particular situation, which may have been abused in years past, or at least some have thought that the materials are there, that these rules, unless there's good reason for it, are respected. We have an alternative to consent, of course. The Crown may suggest that in the circumstances of the case, that as an alternative, the appeal be expedited. So a determination and leave the determination of a stay to be determined at a later time if the appeal doesn't come on as soon as it can come on. Those would be my remarks about stays.
Thank you, Murray. Mark, do you
I
have?
was going to add one comment, if I may, Justice Ben, and that is that the authority isn't completely clear, but in my view, the better view is that there is authority for the granting of a conditional stay, which is something that you ought to keep in mind if it looks like you have a difficult road to hoe with the judge that you are appearing before. And by a conditional stay, I mean obtaining relief from the stay, relief from the driving prohibition to the extent to which the accused can drive for the purposes of employment, by way of example. And in my view, there is power in a judge hearing this application to make such an order. There is certainly such power in conjunction with an application for bail pending appeal, because he can make it as part of the bail conditions.
Thank you, Mark. Well, at this stage of it is our desire to deal with some of the perfection problems, but I think that in the course of the discussion we have touched on them. What I'd like to do is very briefly canvass some of the views of the panel in respect of some of the issues dealing with perfection of the summary conviction appeals. Murray, is there anything further that you wish to say about the requirements as to the notice of appeal, service, filing, time limits, supplementary notices?
I see we have a few questions coming forward, which is good. So I'll be very brief. Most of this has been covered at some point or other during the day. I just want to make the point that for the first time, the notice of appeal and summary conviction matters covers both appeals under 813, the usual summary conviction appeal, and as well appeals under Section 830 relating to appeals on a question of law or an agreed transcript. The 830 appeals are a very rare kind of appeal, and there are those who think that maybe their usefulness or utility in view of merger is no longer there. The only other point I'd like to emphasize in the limited time available is something that was touched on earlier, and that is the appearance for the first time of a rule requiring that a supplementary notice of appeal be filed upon pain of being thought less than one's worth. And that supplementary notice of appeal need be filed in a timely way.
Thank you, Murray. One subject that I would like to turn to very briefly is the consideration of transcripts and legal aid certificates. And Bruce, could you deal with that issue, please?
The transcripts requirements are in Rule 40.06 and following. Basically, and it's been summarized before, what you get in the transcript is only the evidence, the rulings, and the judgment, and then everything after conviction, argument, and reasons for sentence. It's been mentioned earlier about an attempt to get agreed statements of fact within 30 days of filing. I appreciate the reason that's there. Just one point I would raise: if you were not trial counsel and the client has approached you with respect to doing the appeal, it wouldn't it's not all that uncommon that a different counsel than trial counsel reviewing the transcript may very well see a very valid ground of appeal that trial counsel missed. It's not to be critical of trial counsel. I mean, even on cases where we do our own summary conviction appeals, you may see the transcript and wonder what you'd been doing the night before the trial on certain points. I'm not so sure that on reasonably short transcripts that the court should take the position, well, you shouldn't have ordered the whole transcript because you're only arguing one point. It may be there's something in that transcript that's going to assist significantly. Sentence appeals, you get everything in the transcript. If it was a plea, if it's a trial, it's an agreed statement of facts, and then everything after. The reporter, when the transcript is prepared, must notify the court. So the court's going to know at the same time counsel knows, and the cost issue has already been raised or been dealt with. Legal aid, if there is a provisional certificate, has been issued only for an opinion letter, you can file your notice of appeal without the reporter's certificate. If there is no provisional certificate, provided the applicant has applied for legal aid and proof is given to the court office, you do not require the certificate of the reporter, and you obviously don't have to order the transcript. Within 15 days of the area committee's decision, you must file the reporter's certificate. And that's the area committee's decision one way or the other. Those rules are, it's sub 2 and 3, 2, 3, and 4 of 40.06. Those are the legal aid areas dealing with transcripts. The legal aid areas dealing with the amount of work that's going to have to be done will have to be dealt with someplace else.
Thank you, Bruce. Well, the time is running short, and we do want to say a few things about extraordinary remedies. Let me ask you, Bob Hubbard, to very briefly comment about the nature of extraordinary remedies and the way that they differ from appeals, and perhaps to describe the kinds of situations in which extraordinary remedies might be brought.
Well, very briefly, just to refresh your memories as to the nature of extraordinary remedies, the name itself means they're extraordinary. Generally speaking, they're only brought where there's no appeal provision provided for. They are the common law writs. They're specified in the rules, basically habeas corpus, mandamus, prohibition, certiorari, and sometimes procedendo. The writ can only be issued by a superior court in respect of proceedings relating to an inferior tribunal. Generally speaking, for example, they're brought to quash search warrants, subpoenas, preliminary committals from preliminary inquiries. There's other situations which are somewhat less usual. They're discretionary remedies, and generally speaking only lie when there's a question of jurisdiction, a lack of jurisdiction, or a failure to exercise jurisdiction, or error in the exercise of jurisdiction. Habeas corpus has certain particular aspects to it. The remedy is gradually being broadened in terms of its ambit by the cases. I recommend Brian Gover's article in the Bar Admission Materials, which sets out generally the use of the writs and their background and so on and so forth, although it's perhaps a year or two out of date in terms of the cases. You should also bear in mind that increasingly the writ application for the writ is sometimes combined with an application under 24.1 of the Charter in respect of constitutional kind of issues as an alternative or corollary to the prerogative remedies that are sought. Very briefly, I think that about covers the substantive basis of the use of the writ.
All right, thank you, Bob. I want to ask Mr. Justice Paisley to describe for us some of the essential changes in the manner in which these applications will be brought under the new rules?
Well, there are certain procedural changes for those who are familiar with the present rules, some of which are relatively significant in terms of their consequences. Firstly, bear in mind that although extraordinary remedies are dealt with commencing at Rule 43, they are also referred to in Rule number 5, and an application for prohibition must now be served on the court services manager, whereas under the criminal appeal rules, which currently governs the procedure, which you may find in your rules of practice, the civil rules of practice, where the criminal appeal rules are found, these remedies were to be served upon a judge and upon the Attorney General's office. Now, in addition, it is the court services manager to whom the notice is also directed, and it is he who has custody of the documents and who will make the return. Bear in mind, as Bob Hubbard has mentioned, that in referring to a judge, the criminal appeal rules specifically mentioned district court judge amongst the other persons specified, but a general division judge is not subject to prohibition. The general division is the supervisory court to which these applications are brought, and prohibition does not lie, certiorari does not lie against the superior court. So you're essentially dealing with provincial division matters, coroners, and except in relation to the issuance of subpoenas, where even in the general division, where a judge of that court has not issued the subpoena, it may be that such an application will be brought. You no longer have to serve, or will no longer have to serve, the Attorney General's office. It is the local Crown Attorney's office who will be responding to these applications, and that will be a significant change because these remedies have been seen as being relatively technical in nature, and in my experience, counsel with a great deal of experience were ordinarily assigned to respond to them from the Crown Law Office. It appears that now the Crown Attorney's Office is going to have to develop that expertise. Further, and a significant change, is that these applications are to be brought in the region where the matter in issue arises. Typically now, these remedies are pursued largely in metropolitan Toronto, and now they will be pursued in the region where the issue in respect of which the matter arises was heard. And I think that will have an important effect on the practice of counsel who, for example, have to deal with the actions of the executive. The Supreme Court of Canada, in a case called Molino, I won't give you the citation, it's a very well-known case, has held that, for example, habeas corpus applies from the actions of the federal executive in extradition matters. So now I would expect that rather than seeing such applications heard in Toronto, that they would be heard in the Ottawa region. Likewise, some of the cases which Bob Hubbard has argued have dealt with the question of the detention of prisoners. There are cases where the confinement of a prisoner in segregation within an institution has been challenged pursuant to habeas corpus. Most of these institutions are essentially in the Ottawa area, and I expect that these applications will then be dealt with in the Ottawa area. But in relation to the matters emanating out of the provincial division, where there is an issue with respect to committal or any such other issue that arises from the lower court proceedings, they will be dealt with in the region in which the matter arises. So there will be a decentralization of these applications. The substance of the procedure, in my view, is not affected by the new rules. The matters of form are in my view, quite straightforward. When one serves a judge, as is required pursuant to the rules, with an application for prohibition, personal service is required. But I think that I should say that as a matter of discretion and sensitivity, and in fact, in order to avoid an application for contempt being brought in the direction of counsel who attempts to serve such a motion, do not attempt to serve a judge sitting in court. In other words, don't leave it to the discretion of your process server. You must give him specific instructions, and I'd like to recommend that you consider simply having such an application delivered to the clerk of the judge with a request that he or she admit service upon the document. Personal service is required, but an admission of service in almost every circumstance will be readily granted. Those are the general comments that I would make, and I think that about covers it.
Well, thank you, Mr. Justice Paisley. Do we have time to answer the questions? Well, what I have done is I've distributed the questions to those panelists to whom they are addressed, and perhaps I could just ask Murray to start, and we'll deal with them one at a time. Go ahead, Murray, please.
Thank you, Lord. Okay. The question I have is perhaps from a disgruntled defense counsel. There seems to be a great deal left to the discretion of Crown Counsel, i.e., consent to bail pending. Who will control, or what will control, the exercise of Crown discretion? And the questioner raises the issue of costs. Costs would not apply, as far as I can understand, to a Crown in the exercise of judgment withholding a consent. What we're talking about here runs throughout the criminal procedure on all sides of both sides of the bar. I suppose the Crown who unreasonably withholds consent runs the prospect of being censured by the court, especially when one is dealing with a short sentence, and the effect of withholding the consent may unreasonably, if viewed unreasonably, may be viewed poorly by the court, so as to potentially render a matter moot. Ed?
Yes, go ahead, Mark.
My question, I feel like Jeopardy. In a drinking and driving case where the Crown has failed to find your client's drinking and driving record, is it not a violation of your client's right not to be compelled to be a witness against himself if he must disclose his record for the purposes of gaining a stay? Brian Gover is going to think I asked somebody to ask me this question because I happen to agree with the questioner, and I have been concerned about the fact that the rules require disclosure in the affidavit on a stay application as well as a bail application, as they do in the Court of Appeal. Any criminal record, whether or not it was proven by the Crown at trial, and whether in some instances the Crown was aware of it but chose not to rely upon it at trial. For example, there may have been an issue at trial as to whether the Crown could prove the record, and you put the Crown to its proof, it failed, and as a result there was no criminal record before the trial court. Well, the effect of these rules is that nonetheless you must disclose that record in the affidavit because it is mandated by the rules. And there is a certain unfairness in that procedure, in my respectful view, but that is the state of the rules.
Justice Paisley?
Yes, I've been asked this question. Doesn't the rule regarding the costs suggest that appeal counsel is the same as trial counsel, or fully cognizant of everything said at trial, resubmissions, etc.? Let me answer that question by referring to the rule from which the costs issue arises. Unless otherwise ordered by a judge, there shall be omitted from all transcripts of evidence all opening remarks by the prosecutor, etc. And Rule 13, in considering whether to award costs on an appeal, a judge may consider whether evidence has been transcribed or exhibits reproduced unnecessarily. Well, it seems to me that if appeal counsel is not trial counsel and he makes an appropriate inquiry of the trial counsel and isn't satisfied, then he's done all that anyone could ever expect him to do or her to do. I don't see this cost sanction as being imposed arbitrarily. As I said at the outset, I think a judge would be very reluctant to impose a cost sanction, but it's there, and the professional obligation to avoid delay and unnecessary expense is there. And if counsel exerts a reasonable effort to avoid the delay and unnecessary expense by making inquiry, what more could anyone expect?
That's probably just there for Crown Appeals anyway.
Thank you, Justice Paisley. Well, Bruce Durno, there's a question for you.
The question deals with perfecting appeals and transcripts and the problems that we all encounter having court reporters who either won't return our phone calls or just aren't quite sure what they're doing, but whatever it is, it's not producing our transcript. What obligation is there on counsel to write herd on the reporter to make sure the transcript is available? I think increasingly you're going to run into courts who will take the position that the appellant had better write herd, and I would suggest that you start with letters, keep copies of the letters to the reporter. There are, and this has probably changed with regionalization, Murray may know better than I, is there still a court reporter, one person in charge of the whole province, or is it regional now? Do you know?
It's a little of both. In each region, there's a regional court administrator under whom the issue of court reporting falls, and of course they in turn report to someone at 720 Bay, being the assistant deputy minister of courts administration. But you would probably deal with it with that regional administrator if it was.
I mean, I would send a series of letters to the reporter and keep copies of them to file with the court. In addition to that, if it just looks like you're really getting stonewalled, go to the regional administrator and phone them, and in addition write a letter to them so that you can say to the judge, I have done everything I can do. They won't give me the tape, and I probably don't know how to type anyway. Other than that, I've done it.
All right, we have a final question, and I won't direct it to Bob Hubbard specifically unless he wants to answer it, but to the panel at large. And the question is, what effect do you think the passing of the rules will have in the long run on the current bird course status of the criminal procedure section of the bar admission course? P.S. This is a serious question. Does anybody have any views? Well, I think with that, we'll just simply thank you very much.